Hello and welcome to Narayana IAS. As part of weekly current affairs, we shall be focusing on 6 most important topics from the Hindu and the Indian Express. So let's thoroughly examine each and every topic so that you are well informed and armed with information to appear in the UPSC examination and ace the examination. So let's start with the first topic. The title of the next topic is on reservations and the OBC creamy layer. In this article, we'll understand the concept of creamy layer and criteria for creamy layer. And you can map this under GS paper 2. Now, a previous question was asked in the year 2017. This was on the reservation of seats for the women. So, question can be asked on the reservation. Now, let us try to understand the context. We all know the Pooja Khedkar case, who was allotted the OBC. Why? Because she belonged to the OBC non-creamy layer. Now, she had multiple disabilities, but this case was later exposed that this candidate had received a fake medical certificate showing that she was a disabled person and thus got the IAS post. This entire issue surrounds the creamy layer in the OBC reservation. What is the OBC reservation and what is the creamy layer is something that we are going to understand. Now, Article 15 and 16, right? So, in Indian polity, please read what is Article 15 and 16. What is this? It guarantees equality and allows special provisions for the advancement of OBC, SC and ST, which means in matters of educational institutions, admission in educational institutions and public employment, right? The OBCs, SCs and STs are given reservation benefit. Now, this Mandal Commission in 1980 recommended that 27% of the seats in the college and public employment should be given to the OBCs, which means reservation to the OBCs came into being in the year 1990. And then the Supreme Court upheld this 27% reservation to the OBCs, stating that the creamy layer should be excluded from the benefits of reservation, which means the creamy layer should not get the benefit of reservation in the OBC section. Now, how do you understand if a person belongs to the creamy layer or non-creamy layer? So, for example, if the family is earning more than 8 lakh rupees from all the sources, then this person will be considered as part of creamy layer and will not get any reservation benefit. And these are the employment criteria. Now, you can please read this. So, let's say for example, if either of the parent of the candidate belongs to class 1 officer, or if both parents belong to class 2 officers, or let's say a parent is a class 2 officer but gets promoted to class 1, that candidate will not get the benefit and will be considered as part of creamy layer. Or let's say if the parents are holding the managerial position in any PSU, insurance organization, university, then that candidate will also not get the reservation benefit. Or if the parent is holding constitutional position like member of parliament, state legislature, governor, president, even their children will not get the reservation benefit. And then additional considerations. Now, apart from the incomes, the family's overall economic status like the wealth and properties will also be taken into consideration, and non-salary income will also be taken into consideration, which means here through this we need to understand which are the criteria for a candidate to get the creamy layer and non-creamy layer, right? Now, there are some exemptions. For example, agriculture income is exempted. So, if the agriculture income is, let's say, 1 crore rupees, then even in this case, the person will get the benefit of OBC reservation. Non-creamy layer service. Let's say, for example, there are certain service categories and families with lower tier government jobs, like the clerical jobs, etc., might be exempt from this particular criteria. So that the reservation should extend to as many as OBC candidates. Now, there are issues with the current system. One, people are actually obtaining the non-creamy layer certificate using fraud means, like the way Pooja Khedkar obtained by obtaining fake medical certificate. or avoiding tactics. For example, what people are trying to do is they are trying to transfer the property or wealth in the name of the relatives so that they get the reservation benefits. Or now the Rohini Commission said that 97% of the benefits given under OBC are concentrated in only 25% of the OBC communities, which means a major chunk of the OBC population is unable to get the benefit of reservation. And then there is no creamy layer concept in the SCs and STs. So if you're a member of the SC or ST, then this criteria of creamy layer is not applicable, which means the criteria of creamy layer is only applicable to the OBCs and not to the SCs and STs. I hope you understood this article.
Indian government is not very happy with ILO report. So in the previous article only, we have talked about that. We are going to talk about this. So ILO, International Labour Organization, they have published an India employment report where they have not posted or pasted a very hunky-dory picture about our Indian economy, and they have stressed a lot on the unemployment part, and we are not liking it. Indian government is not liking it, and that is but obvious, right? So previous question, International Labour Organization Convention 138 and 182 are related to. So ILO, questions on ILO has been framed by or have been framed by like UPSC. So we should be knowing about ILO. So again, there will be some facts and figures, and there will be a report, and we keep on talking about these reports are important. Global economic outlook, global economic prospect, world economic outlook, and all these different kind of reports. Earlier also we have talked about World Bank, other organizations who are releasing it. Similarly here also, India employment report, keep a tab on it, that who published it? ILO, and India is not very happy about it. Union Labour Ministry claims that ILO's model which they used to assess the employment situation in India is not very suitable for the country, and we have our own assessment. So what are the report findings? So they are saying, ILO report is saying that youth unemployment, if we talk about youth unemployment, India's youth account for almost 83% of the unemployed workforce. So youth population, if there are 100 unemployed people, youth is comprising 83 of them. That is actually a very huge chunk. Education and unemployment, the share of unemployed youth with secondary or higher education, like who have done 12th till 12th or who have done graduation. So they are like almost 66% or 2/3 of the unemployed people. They are the people who have done 12th or who have a degree, who have done graduation. Again, not a very good picture about our employment scenario. So now this is some factual information, and from this particular factual information, what we have to understand, again, I have noted or I have pointed out the key areas. India employment report, who publishes it. Now we have to go to the core part of this article. We have to take out the keywords of this article. One keyword is ILO, International Labour Organization. When was it formed? Is it a part of UN? Was India a founding member of ILO? These are the kind of questions which we should be knowing about, right? So International Labour Organization is a specialized agency of UN, one of the oldest agencies of UN, formed in 1990 as part of Treaty of Versailles. So here, this particular article, different areas are merging. Like when we are talking about ILO, international relations, then international organization here, and then world history, because Treaty of Versailles, which was very much responsible for the Second World War also, because when you keep on reading world history, you hear about Treaty of Versailles, how humiliating it was for Germany and how it paved way for the rise of leaders like Hitler. So Treaty of Versailles, world history, international relation, all these things, economy is merging here. So again, ILO, what are the goals? Fair working condition, like labor welfare. They focus a lot on that. And different conventions of ILO, like there are 8 different conventions. India has signed 6 of them. We'll see that. So they focus like so much on labor welfare, which is actually a very pertinent issue, and fostering peace through social justice. So ILO is unique among UN agencies due to its tripartite structure. Now this is also important. Tripartite structure, 3 parties are involved. What are these 3 parties? First is government, second is employers, third is workers. So understand, they can even ask you which of the organs of UN is known for its tripartite structure. So tripartite structure, ILO, fine. Mandate and objectives, like decent work for all, promoting rights at work, encouraging decent employment opportunity. So there was a bill which was passed in certain state. We'll not talk about the state where they were telling to work for more than 10 plus hours or 12 plus hours. So that is, maybe ILO will not like it because it is promoting decent work for all. It is promoting decent employment opportunity. How much decent that employment opportunity is when you are getting like burnt out in work, right? Enhancing social protection, strengthening dialogue on work related issues. So India and ILO, is India a founding member of UN or ILO rather? we're talking about it, the answer is yes. India is a founding member of ILO, and India has been a permanent member of ILO governing body since 1922. So please understand these keywords. When was ILO formed? Is it an organ of UN? Yes. Was India a founding member? Yes. Then which treaty was associated with ILO? Treaty of Versailles. So all these things are important from exam perspective. Then different conventions which focus a lot on labor welfare. So there are 8 conventions, out of which India has ratified 6. So these are the 6 which India has ratified. And on 138 and 182 already we have seen a PYQ which was asked. So we should be knowing about these 8 conventions: forced labor convention, abolition of forced labor, equal remuneration, discrimination. Then there are 2 conventions which India has not signed: Conventions on Freedom of Association and Right to Organize and Collective Bargaining, where India has issues related to the meaning associated of this convention. And according to India, that there are certain restrictions on government's employees' right to strike and organize in these 2 conventions, and that's why we have abstained from ratifying these 2 conventions. So please bear in mind these 2 conventions: Freedom of Association 87 and Right to Organize and Collective Bargaining.
The next article that we'll be discussing about is Reserve Bank of India has laid down framework in order to classify the willful defaulters. So in this particular article, we'll be discussing about what is this particular framework and what provisions does it actually uphold in order to classify the willful defaulters. Before that, we'll understand who are the willful defaulters and what are the implications they actually face if they do so. So in this particular article, we'll be discussing about this concept of willful defaulter, and we can actually map this particular topic to prelims as well as mains GS paper 3, Indian economy and issues relating to planning, mobilization of resources, growth, development, employment, etc. As well as it forms a part of GS paper 4, determinants as well as consequences of ethics in human actions. Okay. And moving forward, if you actually see the previous year question, there has been a question asked in the year 2012 in the prelims examination with respect to that of the Reserve Bank of India. So any kind of framework, any kind of draft regulations that these kind of institutions actually bring in becomes very, very important. Similarly, the rate cuts, the repo rates, etc. are very important for both the prelims as well as the mains examination. Now let us understand what this particular article is discussing about. So, the Reserve Bank of India has issued stringent guidelines and procedures for the lenders to identify and handle with these willful defaulters. So, let us understand who is a willful defaulter. Okay. So, a willful defaulter is actually an individual or an entity that intentionally avoids repaying the loans despite having the financial ability to do so. So, despite having enough money to repay the loans that you have actually borrowed, if you don't pay, you are termed as a willful defaulter, and defaulters can either be an individual or an entity. So, this includes diverting the funds, siphoning off the funds, or disposing of the collateral assets without the consent of the lender. Next one, if you see, according to the Reserve Bank of India, the classification applies to the borrowers or the guarantors with outstanding amounts of rupees 25 lakhs or more. Now moving forward, let us actually see what are the consequences of being declared a willful defaulter. If a person or an entity is declared as a willful defaulter, what are all the consequences the person or an entity will actually face? First one, restricted access to credit, that is, willful defaulters are barred from obtaining further bank finance, and this actually significantly hinders their ability to conduct future business activities. The second one is legal actions and penalties. Here, the banks and financial institutions actually initiate stringent legal proceedings against the willful defaulters, which can include criminal charges as well as expedite the foreclosure processes to recover the dues under various laws such as the SARFAESI Act, the Companies Act, as well as the Fugitive Economic Offenders Act. So these are the legal implications they will face. Apart from that, they will be forced for public disclosure as well as reputational damage. That is, the names of willful defaulters are made public, which severely damages their reputation and credibility within the finance as well as the business community. So this will actually hamper their further business activities as well, or getting into agreements with other companies. Next one, the directorship restrictions. Individuals associated with willfully defaulting companies, including current and former directors, face the prohibitions on holding the directorship positions in other companies, and this measures actually aims to prevent them from potentially defaulting on their future obligations as well. Now moving forward, next two restrictions that they face is the business restriction. So they are prohibited from establishing new businesses for a period of up to 5 years from the date that they are actually declared as such, limiting their entrepreneurial activities as well as financial ventures. Next one is management changes. Okay, so financial institutions, they will actually have the authority to replace the management of the companies that have been declared, which are willful defaulters, aiming to protect the interest of the stakeholders and ensure better governance as well as to maintain a proper financial discipline. Next one is reporting to CIBIL. CIBIL is nothing but it is the Credit Information Bureau India Limited. Okay, so banks and institutions must submit the quarterly list of all the willful defaulters to the Credit Information Bureau India Limited, ensuring that all financial entities are informed and can take precautionary measures against such individuals and entities. Now moving forward, let us actually understand what is this framework that has been provided by the Reserve Bank of India. First one is identification as well as classification. That is, the framework involves an identification committee and also it has a review committee, and that actually ensure the borrowers are classified as willful defaulters only after they are subject to a thorough process of examination and opportunities for representation. Next one is reporting the requirements. That is, bank and financial institutions must report willful and large defaulters to the CICs, that is the Credit Information Companies, monthly, detailing both the suit filed as well as the non-suit filed accounts. Next one is preventive measures. Institutions again are required to closely monitor the end use of funds, conduct regular inspections on how these funds are utilized, and obtain certifications to actually prevent any kind of diversion of funds or siphoning. Okay. Next is they will be subject to penal measures. That is, it imposes the strict penalties on the willful defaulters that bars them from accessing additional credit and also prevents them from starting new ventures for specified periods of time. Next one, they are subjected to legal actions, we know. The next one is guarantor liability. Here, the guarantors are held co-extensively liable for the defaults and can be classified as willful defaulters if they fail to honor the guarantees. And finally, transparency and fairness. The framework actually mandates transparent mechanism in order to, for the fair application of penalties and also minimize the discretion in the identification process. So this is entirely the concept of who are willful defaulters and what are the consequences that an individual or an entity face if they are actually tagged this willful defaulter.
Anti-conversion laws. In the year 2021, Uttar Pradesh government brought anti-conversion law against the religious conversions. And recently in 2024, the government decided that we will make the provisions of that act more strict, more stringent. And there is a trend in state governments that many state governments are bringing such anti-conversion laws. So we will study these laws. We will also study what judiciary says about such laws. If you look at the syllabus, GS paper 1 says communalism is an important topic and GS paper 2 talks about fundamental rights, and we can relate anti-conversion laws with these topics. If you look at a previous year question of 2017, it says distinguish between religiousness or religiosity and communalism, giving one example of how the former has got transformed into latter in independent India. And to answer any such question, you need to have a comprehensive understanding of the Indian society and the laws that are being made in recent times. Moving ahead, what are anti-conversion laws? If you look at the Article 25 of the Constitution of India, it says that any citizen of India will have freedom to practice, profess and propagate any religion. That means I have the choice. I will decide which religion I will follow. So in that case, that means I even have the right to convert to any other religion. And this depends on my own choice or my own free will. But what happens in case someone is forcefully converting me from one religion to other? In that case, state comes into picture. State says, we are bringing anti-conversion laws. In case someone is forcibly, or we can call it through coercion, through fraud or through any other illegitimate means, if that person is converting you from one religion to other, we will not allow that. But there are some critics who say that such laws are brought in to favor the dominant religion in the society, and it goes completely against the minority groups. If you look at the provisions made under the Act of UP government and the amendments that are proposed very recently, they say that we are expanding the scope of filing FIR. For example, there is a couple in which one person has converted the other's religion. In that case, even if you do not belong to them, even if you have no relation with this couple, still you can go ahead and file the FIR, because any person is allowed to file that. So this brings the community participation as an important part of social processes. Moving ahead, there are some stringent bail conditions made under this act. Usually you see, jail is not given to anyone, rather bail is given. So bail is the norm. But when it comes to any serious crime, you are not given bail in an easy way. So in this act also, they have ensured that you will not easily get any bail. First, the prosecutor's opposition has to be ensured, and the judiciary will have to be satisfied that the person is very innocent. Next, the punishments have been increased in terms of jail as well as fines. And there is a new category of offense added in this act. It says that in case there is a person in the foreign country who is trying to convert you through the funding, he is providing the funding, in that case, he will also be brought under this act. Now, moving ahead, why any government will bring any such law? What is the rationale? What is the reason? The first is to ensure your Article 25 or the fundamental right, in which we are saying that you should not be forcefully converted to any other religion. Your fundamental right matters. Second is the social harmony. If mass convergence take place in a society, there is a chance that communal harmony will not be there in that society. There can be some kind of conflicts which will lead to chaotic situations. Next, protecting the vulnerable groups. You see, any strong person can do whatever he wants to. But the vulnerable people like the minors, women, or economically disadvantaged individuals, they will usually be forced by the mighty or powerful. So we want to protect these vulnerable sections. Apart from that, we want to protect cultural heritage of the country. So in case convergence are taking place, there is a chance that there can be cultural influence of other religion or other culture. So we want to protect our culture. This is the reason the government is bringing such laws. Moving ahead, there can be a political factor wherein a political party whose voter base may get happy due to such acts. So in the name of vote bank politics, they may go for bringing such anti-conversion laws. Then there is an angle of national security. I said there can be a possibility of foreign influence. So in case a foreign political power wants to disrupt your state, they want to bring an extremist ideology in your country and to disturb or create chaotic situation in your country, then this goes against national security. And as a measure, a preventive measure, the government may bring anti-conversion law. Now let's move forward. If we talk about the concerns related to these laws, if any government brings any such laws, in that case, the first issue is about the religious freedom of that person. You see, you said that Article 25 says you have right to freedom of religion, you can practice any religion. So, by these laws, government is actually curbing the Article 25. This is what critics are saying. They are also saying that there is a potential for misuse. Whenever you give such power to any local authority, he or she may misuse that authority and suppress the minority religious groups. Then there is ambiguity in the definitions given in the Act. If you look at the Act, it mentions about force, fraud, inducements. Now, these terms are very vague and any authority may use it whimsically or in an arbitrary manner. So, there are chances of misuse again. And then there will be a chilling effect. There can be a genuine person who is genuinely converting from one religion to another. But because there are anti-conversion laws and anyone may file the FIR, there is a chance that such person will suffer due to such acts. Then there can be social and cultural division. So there is a possibility that us versus them phenomena may get established, wherein this culture and that culture become separate. The division or the divide further strengthens. Then there's this love jihad controversy. Although this term love jihad is not officially used by Ministry of Home Affairs as such, but this term is usually used in an unofficial way, saying that if a Muslim man tries to marry a Hindu woman by luring her in the name of love and marriage. So this term is very much used, targeting such couples. So here, the right to life and personal liberty under Article 21, right to equality under Article 14 are violated. This is what critics are saying. Now, moving forward, we'll look at what the judiciary says on this matter. And there is an evolution of cases. If you look at the 1995 case, Sarla Mudgal case, in which court observed that Hindu marriage cannot be dissolved just because you have converted to Islam. So, for example, if a Hindu man, he says that I want to remarry, I want to go for second marriage, and for that purpose, I am converting to Islam. So here in this Sarla Mudgal case, Supreme Court said that this second marriage will be void. We will not allow this. Your first marriage is the official one. Secondly, if you look at the Pushpa Bai Selvaraj case of 2001, it says that right to genuine and voluntary religious convergence are allowed and the free choice is important. The third is of 2006 Lata Singh case. In this case, court said that there is a right of any adult woman to marry person of her choice, and whoever she chooses, there is no role of any society, any member of the society or any family member. Her choice is very important. The next is Hadia case of 2017, in which Supreme Court says that the right to choose religion and the right to marry a person of choice, this is important and we value it as per our fundamental rights. So if you look at these judicial rulings, it clearly says that fundamental right is very much important. But Supreme Court also understands that the social harmony can be disturbed. So here, as a way forward, we can say, firstly, we need to clarify the definitions so that there will not be any ambiguity and the misuse of these terminologies will not be there. Secondly, we need to strengthen the legal frameworks. First of all, whatever laws we have, we need to review them. We need to update those laws and we need to bring standardized procedures. And the role of judiciary becomes very important. In case any executive authority misuses these acts, in that case, judiciary will have to play its role. Then you need to promote public awareness and education. Only through the education and awareness, you can ensure social harmony in the society. And you need to encourage interfaith dialogue. If there is this situation of us versus them, only this interfaith dialogue, when people will communicate with each other, they will understand each other, and this us versus them mentality can be removed. And at last, you can align the international standards with your national laws. That means national laws should be updated in such a manner that international standards are maintained. So you need to ensure human rights are protected, and you also need to ensure that cultural rights are also protected. So there is a need of balance.
Fascinating article, a recent Supreme Court judgment has come. And just like we do sub-classification in OBC category, sub-classification will be done now in SC/ST categories as well. What is the need for that? This article deals with that and we'll try to understand it. Various articles today have come on this sub-categorization of SC and ST and the Supreme Court judgment. And we'll talk about it in detail. So this reservation, all these things, the questions have come earlier as well. So what is the context here? The Supreme Court of India recently ruled that states can create sub-classification within the scheduled caste and scheduled tribes. So what is the basic argument? 6:1 judgment it is. 7-judge bench has given the ruling. Now again, it's a question for you. You have to tell me and you have to post in the comment section if you know it. If it is a 7-judge bench, is it a constitutional bench or non-constitutional bench of Supreme Court? What is the justification for creating sub-classification? They are saying that just like in OBC category, there are certain people or certain sections which have enjoyed much better benefits compared to the other sections. Similarly, here also in SC/STs, there are certain communities inside SC/ST who are well off, and there are some other communities who are not enjoying the benefits of reservation, who are very backward. So we need sub-classification to understand which categories under SC and ST are well off and which are not so well off. This sub-classification is the need of the hour, and we'll take some data from this article to substantiate this fact. So what is sub-classification? Sub-classification refers to division of a larger category into smaller, more specific groups based on distinct characteristics or criteria. Approach aims to ensure that affirmative action, which is the other name of reservation, in education and employment are more equitably distributed. Within SC/ST also, if there are certain communities which are well off and other communities which are not so well off, then obviously you need to give reservation or more protection to those sections inside an SC and ST rather who are not well off. So that is what this article is talking about. That is what the Supreme Court judgment is talking about. And by recognizing the internal diversity and disparities within ST and ST categories rather, sub-classification seeks to provide targeted benefits and protection to those who need them the most. Example, statewide. Now, we have given some theoretical points. Now, let's substantiate it with facts. So, there are states, they are total SC caste. Maharashtra, 37. Prominent or dominant SC communities which are enjoying most of the benefits are Mahar and Matang. Other communities are not so well off. So again, you can understand here the other SC communities who are not enjoying or who are more backward. So they need more protection. Rajasthan, 59 SC caste. The prominent or dominant SC communities are Meghwal, Bairwa, Jatav. This is important again from other perspective as well. You need to know from where these communities belong. That can also be asked in UPSC. Chhattisgarh, 44 total SC caste. Bairwa and Raidas. These are the dominant SC communities. Other are not so dominant, not so well off. Tripura, 34. The prominent or dominant SC communities are Das, Badhyakar, Sabatkar, Sarkar. So you can understand here 44, dominant are 4, or 34, dominant are 4, 44, dominant are 2. What about the other 42 communities in Chhattisgarh? What about the other 35 SC caste in Maharashtra who are not so well off? Don't they need more protection? That is what this judgment is talking about. So now there have been different judgments related to this particular issue only. So E.V. Chinnaiya versus State of Andhra Pradesh 2004. They said that no, SC and ST should be treated as a homogeneous group and we don't need any sub-classification because that would violate right to equality under Article 14. Then Davinder Singh versus State of Punjab case, which is 2020 recent case, it said that no, there are inequalities within SC/ST categories which we are seeing from that different state data and there is a need for reconsideration of E.V. Chinnaiya decision. What is the legal framework or what are the legal frameworks? 341, 342 of the Constitution empower President to notify certain caste. So again, they can ask you which articles empower President or who notifies certain caste, President, Governor, etc. So the answer is President. And these lists can only be amended by Parliament. Then 15 clause 4 allows states to make special provisions for advantage or advancement of socially and educationally backward classes rather, including SC and ST. 16 clause 4, here we are talking about different constitutional provision. Enable states to provide reservation in public employment for any backward classes of citizen that is not adequately represented in the services under the state. So, recent ruling, majority opinion, this particular judgment, 6:1. What they are saying? 6 are saying that yes, we need sub-classification. Then there is one dissenting opinion by Justice Bela Trivedi. And she is saying that no, such sub-classification could lead to further fragmentation and discrimination within SC/ST communities. The 6-judge bench who gave this favorable opinion, they recognize that not all groups within these categories are equally disadvantaged and that targeted measures are needed to uplift the most marginalized among them.
The 5 guidelines to dragon elephant tango. Your dragon attributes to China and elephant attributes to India. Right, so in this article, we are going to understand the India and China relations and you can map this under GS paper 2, right? So let's go through a previous question asked in the year 2017. China is using its economic relations and positive trade surplus as tools to develop potential military power status in Asia. In the light of the statement, discuss its impact on India as her neighbor. So such type of questions can be asked in the UPSC examination. So let us try to understand the context. The Chinese ambassador to India. Now, this ambassador has discussed the framework for improving the India and China relations. We all know that the India and China relations are fraught with tensions, political tensions, military tensions, economic tensions. In order to overcome these challenges, the Chinese ambassador has provided certain guidelines and framework to overcome the challenges. And these challenges, they are based on 5 principles. Which are these 5 principles? Mutual respect, mutual understanding, mutual trust, mutual accommodation, and mutual accomplishment. So respect, understanding, trust, accommodation, and accomplishment. Very, very important point which you can mention in your mains answer. So please note this 5 principles: trust, understanding, respect, accommodation, and accomplishment, right? And these guidelines, they aim to bring the India-China relations back to a stable and sound track. This is the purpose of the principles. This is the context. Now let us try to understand the India and China issues, and so that we can focus on the solution to overcome the challenges. The relations between both the countries are marked by historical, political, and economic issues, and these are long-standing and complex issues between both the countries. So let us try to understand each issue one by one. The first one is the border dispute. When it comes to border dispute between India and China, now India and China have border dispute in the western sector, in the eastern sector, as well as the central sector. Now, let me just help you with a diagram. This is the western sector. This is the Aksai Chin region. This is the McMahon line. Now, McMahon line is a line that divides India and China, right? Now, China does not recognize this McMahon line. China claims Arunachal Pradesh, right? China claims Arunachal Pradesh, right? So, this is the western sector and this is the eastern sector, and this is the central sector around Sikkim. So, these are the border disputes between India and China. Now, what is the solution? The solution is there has to be mutual accommodation between both the countries, and both the countries have to resolve the disputes through dialogue and peaceful negotiation. Dialogue, you mean there have to be diplomatic talks. Then there has to be military communication channels which should be open, which means the military leaders of both the countries should be engaging so as to build confidence building measures. It is very important that both the nations have to work towards confidence building measure, as we had framed during the year 1993, agreement on the maintenance of peace and tranquility along the India-China border. So, diplomacy is the only way through which we can resolve the border disputes, and there has to be frequent diplomatic talks between both the nations. So, the first one is the border dispute, the western sector, the eastern sector, and the central sector, right? Now, recently in the year 2020, there's a Galwan clash, right? Both the militaries of India and China, they clashed against each other. There was skirmish that led to the lives of few Indian soldiers as well as Chinese soldiers. So, this is the first issue. The second issue is the economic competition and the trade imbalance. Now, both the nations have trade imbalance, which means we import more from China than what we export. So, there's trade deficit with India, right? Now, if you see the 2024 trade, the trade was around $120 billion, which has reduced from the last few years. We import around 100 billion worth of goods from China. We export only about 16 billion worth of goods. So, the trade deficit amounts to $85 billion, which means we owe this amount to China, $85 billion. This is the second issue. So, solution, how do we overcome this issue? By emphasizing mutual accomplishment. Both the countries have to enhance economic cooperation. Now, how do you cooperate? You have to cooperate on sectors in which both India and China complement each other, such as technology, pharmaceuticals, and renewable energy. Collaborative ventures and easing restrictions on bilateral trade can help to arrive at a balanced trade relation between both the nations, which means we have to leverage each other's strengths. We have to focus on joint ventures where both India and China can benefit by trading with each other. These are the top 10 items exported to China, and this we import from China. So, please go through it and try to remember few goods. This is the second issue. First one, border issue. The The second one was trade imbalance. The third one is the geopolitical rivalry. The geopolitical landscape of the world, they see India and China both as competitors, especially in the Indo-Pacific region. Now, China is having close ties with Pakistan, and China has invested massively in China's Belt and Road Initiative, which is conflicting with the India's interest. Now, what is Belt and Road Initiative? So, this is the Belt and Road Initiative, BRI. Belt and Road Initiative. One belt and one road initiative. Belt is the maritime route. The belt is the Silk Road. Now see, this is China. So China is trying to connect to Africa, Europe, right? One through maritime route, the other one through Silk Road. The reason why China is investing massively in infrastructure is because China can export their manufactured goods to different parts of the world. For that, you need infrastructure, and that's the reason China is investing massively in infrastructure. Right? So this is the Belt and Road Initiative. But the problem with Belt and Road Initiative is it is passing through India, Jammu and Kashmir. That's the reason it is conflicting with India's interest. I hope you understood the point. And what is solution? Both the countries need to have mutual trust. Both these countries have to see each other as partners and not as rivals. Right? So again, both the countries have to focus on dialogues and multilateral platforms for better understanding and coordination. Right? Now, which are these multilateral platforms? Like, for example, we have Shanghai Cooperation Organization, we have BRICS. So these are the platforms where both the nations can engage with each other to find solution to the problems. This is the third issue, the geopolitical rivalry. The fourth one is the trust deficit. Now, given that there are historical tensions between both the nations, starting with the 1962 war, 1967 war, and there have been frequent skirmishes or standoffs, this has actually harmed the relation between India and China. And the nationalistic media narratives, they influence the public opinion in both the countries. And that's the reason people have hatred against each other, right? And the solution is we have to enhance mutual understanding. And how we can do it? By focusing on soft power. What is soft power? Cultural exchanges. Now, India and China have cultural relations, historical cultural connections. We'll see this in the next slide. Academic collaborations, there have to be scholarship programs wherein Indians can go to China and Chinese can come to India, people to people contact, so that the perception that we have for each other can be filled, right? So this can be the solution. So these are the four issues that we have discussed. One is the border issue, the economic issues, the geopolitical rivalry, and the trust deficit. Now, the other dimensions which have been mentioned in the article. One is the cultural and historical ties. As I told you, both the countries have a long historical and cultural connection. For example, the ancient Nalanda University and the monk Wanzang's travels. The connections between these two universities emphasize that India and China had long historical and cultural relation, and we have to use this platforms. For example, India has revamped the Nalanda University. So these monuments or these things can act as a fodder, or they can literally cement the ties between India and China. They can act as foundation for strengthening the modern relations. And how we can do it? How we can strengthen the modern relations? Through cultural diplomacy and heritage tourism. The second one is the Global South cooperation. Now, Global North is attributed to all the developed countries, and Global South is attributed to all the developing or poor countries, right? Now, India and China can emerge as, or they can play very, very important role in shaping the future of Global South. India and China can be the leaders of the Global South and can understand the issues of the Global South and find solutions to their problems. So we have platforms like BRICS and SEO that we just discussed, we can use this platform, both the nations, to promote the interests of the developing or poor countries. The third one is the technology and innovation partnership. Now, technology and innovation partnership, both the countries can act as leaders in technology and innovation. That is, we both can collaborate in artificial intelligence, space exploration, and digital economy. Collaborating in technology will not only boost relations between both the countries, but also contribute to the global technological advancement. Right? And then way forward, again, all these points we have discussed already. We have to strengthen diplomatic channels. There have to be frequent diplomatic engagement between both the countries. Then promote economic integration. We have to sign trade agreements with each other so that both the countries benefit by trading with each other. We have to focus on infrastructure, technology, manufacturing. Right? Then enhancing cultural and academic exchanges to promote soft power. Now, this will generate goodwill and mutual trust for people in each other. Collaborating on global challenges. Both the countries can emerge as leaders to address the emerging challenges like climate change, pandemic response, and sustainable development. And fifth one is, in order to find solutions to the regional security, right? The South Asian region, or let's say the Asian continent, or the economic policies, both the countries need to have strategic trust. So by implementing all these 5 guidelines, India and China relations can be smoothened, can be improved. So in order for the development of South Asian region as well as the Asian continent, it is very, very important that both India and China have to come together, collaborate in technological sectors, and ensure that there is mutual trust, mutual advancement, so that with India and China, the entire continent will benefit. I hope, students, you understood each and every dimension of this article.